Hello, everyone. I'm Alonzo Martinez, Associate General Counsel at HireRight, and this is Compliance in Focus, the second installment of our quarterly webinar series and our mid-year update. While I am a lawyer, today's webinar is not intended as legal or compliance advice. My intentions are to give you information that you'll take as talking points to raise with your teams and your legal counsel. That said, pick up your phone and snap that QR code to follow me on LinkedIn. I post compliance content weekly, so a good opportunity for us to make friends. As always, before we begin, I want to cover a few housekeeping items. During this webinar, please take the conversation to Twitter or X using the hashtag HireRightWebinar. In order to receive HRCI or SHRM credit, you must attend the full live session of the webinar. Credit information will be emailed to you next week. Again, we'll get that credit information to you next week. We're not providing copies of today's slides. However, when we send out your credit information next week, we'll send you an email with a link to a recording of this webinar session. If you are experiencing audio or video issues, please refresh the browser window by clicking F5 on your keyboard or send us a message using the Q&A icon at the bottom of the screen. Carrie is producing today's webinar and is monitoring the feed for any technical issues. After the presentation, we would appreciate getting your feedback. So please take our brief survey and let us know if this session was helpful. My focus here at HireRight is to create sessions that are meaningful, so I welcome ideas for future topics. So please, again, take 60 seconds out of your day and let us know what you think. And again, if you have any audio or video problems, press F5 on your keyboard to refresh this presentation. Today, we are sharpening the details on the ever-evolving landscape of employment legislation and litigation. Currently, only 12 states and 3 territories remain in regular legislative sessions. So as we dive into this mid-year update, we have a clear view of the laws that impact your screening programs. And that's what we're going to cover today. You can see the rundown on the screen. I'm going to provide an overview of the current state of the law and offer some practical guidance to comply or prepare to comply with those laws. And as always, we have a lot of ground to cover today. I'm going to try and keep a quick pace through these topics. So please do not consider this to be an in-depth discussion of any one topic, but it should provide you with a good foundation upon which you can explore. And I should mention that if you click the resources icon on this webinar, you'll find links to materials that'll help you through your compliance journey. Those links are a great resource for you to bookmark. I've written a lot of content concerning the topics we're going to cover today, as well as provided links to some authoritative guidance. So check out that resources area. And I'm always looking for new opportunities to create content that benefits you. So when you fill out that survey, let me know what you'd like me to focus on in future webinars. So as always, settle in for the next hour. Remember, if you have any questions during this webinar, use that Q&A icon and I'll try and cover those at the end. We're going to kick things off today, as always, with a broad discussion concerning criminal history reform. And here's a look at states across the United States that have implemented clean slate laws. Clean slate laws, they expunge or seal certain criminal records from public access once somebody remains crime-free for a specified period of time. The goal of clean slate laws is to remove the stigma associated with criminal history so that individuals that have offended have an easier time of getting a job. The impact on you as employers is that if a record has been sealed or expunged from the court's indexes, then it can't be found. So if it's been sealed or expunged and removed from the court's indexes, it won't be reported to you on a criminal background check. As you can see on the screen, every state except for Wisconsin offers some form of post-conviction expungement or sealing of qualified criminal offenses to varying degrees, from states in red that extend to felony and misdemeanor convictions to those in that orange or terracotta color that apply to limited offenses as specified by the state. Those states that feature a star offer automatic expungement or sealing of qualifying crimes, while those without a star require that an ex-offender petition the court for relief. Wisconsin offers judicial pardons, but criminal records are not sealed or expunged. For more information on clean slate laws, check out the links to our automatic criminal record relief volumes 1 and 2 in the webinar's resources section. Great materials that we have put together for you. Now let's dig into clean slate laws that progressed in the first half of 2024, starting with Pennsylvania's Clean Slate Law version 3.0. In 2023, the governor signed Act 36 of 2023, which expanded Pennsylvania's Clean Slate Initiative. Initially signed into law in 2018, Pennsylvania was the first state to automatically seal criminal records. And Act 36 represents the third expansion of this law, hence Clean Slate 3.0. So let's cover those updates for you. First, the revised law clarifies that employers are now protected from being sued if they hire somebody with an expunged record who later commits wrongdoing, provided that the candidate voluntarily discloses that expunged record. Previously, there was some ambiguity about whether employers could face negligent hiring lawsuits in such cases. The updated law now explicitly grants employers immunity from that liability. Second, Act 36 extends the availability of automatic expungements to individuals who have received an unconditional pardon. Once cleared, employers cannot use this information for hiring unless required by federal law. Again, in Pennsylvania, you cannot use a pardon unless required by federal law. Additionally, Act 36 expands the types of criminal offenses eligible for clean slate treatment and includes automatic sealing of records for nonviolent drug felonies after 10 years without additional convictions. Third, the law reduces the waiting period for automatic expungements for the offenses as detailed on the screen. This applies to those ex-offenders who remain conviction-free during those defined waiting periods that I've included on the screen for you. So Act 36 took effect on February 12, 2024, except for that automatic sealing. That became effective earlier this spring, June 11th, 2024. So this means that the backlog of eligible records should have been sealed by that date. And just a quick compliance reminder, under existing Pennsylvania law, employers are generally required to only consider job-related misdemeanor and felony convictions when making hiring decisions. These updates to Pennsylvania's Clean Slate Law provide clearer protections for employers and expanded opportunities for individuals with expunged records. Moving on, Governor Wes Moore of Maryland has issued an executive order pardoning 175,000 convictions for cannabis possession. It's the largest initiative of its kind in the United States. This affects individuals with misdemeanor cannabis possession and certain drug-related paraphernalia convictions. For employers, understanding the difference between pardons and expungements is really critical. Pardon convictions remain on records, but they indicate forgiveness. So here's your compliance reminder. A pardon conviction will be reported unless prohibited by a particular state's law. So employers may need to adjust their policies regarding hiring practices when considering these pardon convictions. Again, it's important to decide the job relevance and the impact of a pardon conviction as part of your adjudication and employment decision process. As we continue with our criminal history reform discussion, let's take a look at the landscape of ban-the-box jurisdictions impacting private employers at the state and local levels. In all 39 of the jurisdictions on the screen, you can't ask, have you ever been convicted of a crime until later in the hiring process. In the 20 jurisdictions you see on the screen in red text, the ban-the-box measure applies to any form of work for monetary gain. So if you pay somebody to do a job, they're subject to the ban-the-box measure. So this would include not only your traditional employees, but also contractors. You know, I love to say this, not all ban-the-box laws are created equal. In all ban-the-box jurisdictions, you generally can't ask the candidate if they've ever been convicted of a crime during the initial application or request a criminal background check before a conditional offer. Those are those jurisdictions in that gray standard box. On your screen, you're going to see those in that aqua column that require that you identify the criminal conduct that may disqualify a candidate from hire and provide them with a notice as part of the pre-adverse action process. There are those in the blue column that require that you conduct and provide an individualized assessment that relates the candidate's criminal conduct to their job as part of the pre-adverse action process. And then you have Los Angeles and New York City shown in that wine-colored column on your screen. In those jurisdictions, you also have to provide additional city published notices or substantially similar forms as part of the pre-adverse action process. And then there are 4 jurisdictions: Louisiana, New York, Atlanta, Georgia, and Gainesville, Florida, that don't specifically ban the box, but do require that you conduct individualized assessments. As a reminder, an individualized assessment is your analysis of the candidate's criminal history and its potential relationship to the position for which they are under consideration. While you have to perform the analysis, you don't necessarily need to provide it to the candidate unless specified by that particular jurisdiction's law. I always reference the EEOC, the Equal Employment Opportunity Commission's 2012 guidance to employers concerning the use of arrest and conviction records as a good read that can help you understand the individualized assessment process if you're unfamiliar with it. I've linked to that guidance in the resources section of this webinar. It's incredibly helpful, so please give it a read if you haven't already. As you can see, you can't adopt a one-size-fits-all model for compliance. You're going to have to modify your adjudication and pre-adverse and adverse action practices to align with a particular jurisdiction's law. So with that said, just a quick reminder that you can use HireRight's compliance workbench solution to manage your ban-the-box obligations. The solution is made available to you for free. So let us know if you want more information when you complete the survey. And a quick plug, you can find our Ban the Box white paper in the resources section of this webinar in the resources library. If you're a HireRight client, you'll also find our sample pre-adverse and adverse action templates for your reference in Compliance Central and within Screening Manager. Let us know if you need help finding those. So let's discuss the latest addition to our list. Lehigh County, Pennsylvania, which recently passed an anti-discrimination ordinance that includes a ban the box component. Fortunately, Lehigh's ban the box law imposes a straightforward restriction. It prohibits employers from inquiring about an individual's criminal convictions on an initial employment application. Although the ordinance doesn't mandate an individualized assessment of an applicant's criminal history, it does require employers to consider whether the conviction records are relevant to the applicant's suitability for employment. So generally a very straightforward ban the box measure, but it does require this job relevance component. Let's stay in Pennsylvania and talk about what's going on in Philadelphia. You might remember that in 2011, Philadelphia is one of the first cities to ban the box, effectively to say that private employers couldn't ask about a person's criminal record until they were offered a job. They've amended their ordinance a couple of times since then, 2018 and 2021. Basically, the city's ordinance prohibits employers from asking about a candidate's criminal record until after a conditional offer has been extended. Also, an employer can't refuse to hire someone just because they were arrested but not convicted. If an employer does decide not to hire someone based on their criminal record, then they have to conduct an individualized assessment. They have to look at each criminal case individually to see if it's a risk for the job. The recent amendment to Philadelphia's ordinance concerns what employers can do if somebody's criminal history is exonerated. Exonerated means that they were found not guilty after initially being convicted. The revised ordinance tells us that an employer is prohibited from rejecting someone because they are exonerated or found not guilty later on. And being found not guilty could mean a few things, like being pardoned or acquitted or having the case dismissed by a court. The revised ordinance also changed how far back employers can consider someone's criminal record. Before, the look-back period was 7 years. Now employers are limited to considering 7 years of criminal history, but they also can't consider convictions that were later found not guilty. So again, it was a 7-year standard, but now it's 7 years plus no consideration of exonerated records that were later found not guilty. Just a reminder, Philadelphia has one of the most prolonged waiting periods between the pre-adverse and adverse action notice process. You have to wait at least 10 days from when you notify the candidate that you may withdraw their conditional job offer because of their criminal history to the date that you actually withdraw that job offer, should you choose to do so. So you're going to want to ensure that that 10-day waiting period is built into your process if you hire candidates in Philadelphia. Again, you can use Compliance Workbench to help manage those requirements. Moving on to the nation's most onerous ban-the-box law, and that's the recent ordinance passed that impacts employers in unincorporated areas of Los Angeles County. I see a lot of reference to this as the LA County ordinance. It's actually the unincorporated areas of Los Angeles County. So LA County has an ordinance, and then there is an additional ordinance applicable to the unincorporated areas of Los Angeles County. That's what you see on the screen, and that's what we're covering today. So first, it applies to any work for pay in an unincorporated LA County. So traditional employees, contractors, gig workers, and freelancers are all in scope. Employers are prohibited from inquiring about an applicant's criminal history before extending a conditional job offer unless they're legally required to do so. The ordinance also has several notice requirements. For example, when an employer plans to review an applicant's criminal history as part of the conditional offer of employment, they need to list all the essential job responsibilities in a job post. So that's going to be very different for you, right? If you're going to review criminal history, you have to list all the essential job responsibilities in that job post. The employer also has to identify any tasks where they think that the candidate's criminal history might make it hard for them to do the job well and could cause the employer to withdraw a conditional job offer. Once that job offer is made, employers can't inquire about an applicant's criminal record until they obtain the criminal background report. So that's different, right? They have to share the report with the applicant before discussing the applicant's criminal history with them, before asking about any more details or providing a questionnaire about their criminal history. So practically speaking, this means that you can't ask an applicant to self-disclose their criminal history even after a conditional offer of employment has been extended. You can't talk to them about their criminal history until they have a copy of the criminal background report that you're looking at in their hands. Okay, what's the sequence of events when considering an applicant's criminal history? So I'm going to walk through the whole life cycle with you. When considering an applicant's criminal history, employers first have to conduct an initial individualized assessment to determine if that criminal history has a direct adverse bearing on the applicant's ability to perform their job duties. If the employer intends to take adverse action based on this initial assessment, they have to follow a specific process, including providing a preliminary notice of adverse action to the applicant, allowing them time to respond, and conducting a second individualized assessment if the applicant provides additional information. So let's break this down and talk about the modified pre-adverse action process. Once the employer finishes their first assessment and decides that they may revoke the job offer or take an adverse action, they have to give the applicant a pre-adverse action notice that serves as a warning. This notice should be sent both by regular mail and email if an email address is available. So again, this is really different. You'll have to send it by regular mail and email if you have that applicant's email address. The pre-adverse action notice has to include a few things. First, a reason for withdrawing the offer or taking action based on the criminal history, information about the applicant's right to respond before the final decision, the response deadline. So that response deadline also has to be clearly highlighted in bold, underlined, or capital letters, and an explanation that the response can include evidence challenging the background check's accuracy or information on rehabilitation or other relevant factors. After getting the initial pre-adverse action notice, the applicant has at least 5 business days to reply. If they dispute the background check as being incorrect or need time to gather evidence for their defense, then they get 10 more business days to respond. So you're potentially now 15 days out from that initial notice. So what happens if an applicant shares evidence of rehabilitation or mitigating circumstances regarding their criminal history? If an applicant provides such evidence, then you have to do another individualized assessment. What happens if the employer decides to take a final adverse action, like withdrawing the job after that second individualized assessment? So after the second assessment, if the employer decides on a final adverse action, you're going to withdraw that job offer. They have to inform the applicant in writing, again, by regular mail and by email, both, if possible. And that adverse action, that final adverse action, has to include several things: a final decision to withdraw the offer or take adverse action, a copy of the second individualized assessment, the convictions leading to the final adverse action, information on how the applicant can challenge or request reconsideration of your decision, details on filing a complaint with the Los Angeles County Department of Consumer and Business Affairs, the DCBA, and the state's civil rights department. And if the adverse letter is sent more than 30 days after the applicant's response to the first notice, an explanation for the employer's delay due to whatever circumstances were beyond the employer's control. Here's another interesting piece for you. Employers cannot withdraw a job offer just because of a delay in receiving a criminal report. You know that criminal reports in Los Angeles County can take a very long time. But if waiting would seriously disrupt business and 10 days have passed since the criminal history request, the employer can make that adverse decision. But the employer first has to tell the applicant in that initial notice why the delay is causing problems and follow specific notification procedures as outlined in the ordinance. So that's a lot of information, right? That is the very highly complex ban-the-box ordinance that will become effective this fall for employers in unincorporated areas of Los Angeles County. Again, not LA County, but unincorporated areas of LA County. I've written a step-by-step guide that breaks down the ordinance in a kind of Q&A format that I previewed in our talk today. I've linked to that in this webinar, so I encourage you to check that out. Here is our recap. I always try and provide actionable guidance to help sharpen the details on compliance. Clean slate laws continue to gain traction, which means you'll likely see a reduction in the number of criminal records reported to you. Similarly, many of these clean slate laws and ban-the-box laws restrict your ability to inquire into a candidate's criminal history. If you ask candidates to self-disclose their criminal history, periodically review your questions and any state or local instructions or notices that you provide to those candidates to maintain compliance with those laws. Your responsibility as an employer is to ensure that those notices and questions are compliant and relevant to your screening program. Regarding pardon convictions, remember that in most cases, except for California and New Mexico, they're going to be reported to you. You will have to determine how you adjudicate them. It's really important to be familiar with and have processes in place to comply with the specialized notices and assessments required in ban-the-box jurisdictions. Hiring in unincorporated Los Angeles County, for example, requires specialized notices and an enhanced individualized assessment process. You can't use your standard pre-adverse and adverse action letters in the jurisdictions that require special handling, such as Philadelphia and unincorporated LA County that we covered today. So you're going to have to ensure that your letters are tailored specifically to the requirements of those ban-the-box ordinances. If you are a HireRight client, you can manage those processes in Compliance Workbench or outside of your platform if you prefer. But again, you can't take a one-size-fits-all approach to ban-the-box compliance. HireRight customers, you are going to receive a communication in the next few weeks with information on changes to Compliance Workbench to help you manage your responsibilities with ban-the-box requirements in unincorporated LA County and in Pennsylvania. This communication will include access to our revised ban-the-box white paper, sample pre-adverse and adverse action letters, and individualized assessment templates for your reference. Again, look for that communication in early August. As we close out this section, I want to remind you to get your questions in using the Q&A icon at the bottom of the screen and check out the resources section of this webinar for more information. I'm seeing great engagement, so thank you so much for getting your questions in. Every item that I've covered so far has had a corresponding article if you want to learn more. So again, check those out, bookmark them, and save them to read later on. Let's shift gears and talk about pay equity measures. Remember that pay equity measures promote equal pay for equal work and often include a ban on asking a candidate about their former compensation until some later point in the hiring process. And pay transparency measures require that you share a pay range with candidates and in some cases also with employees. And you may also have to include benefits information. We're going to cover that in just a minute. So here is a map that I've created that shows the jurisdictions prohibiting you from asking a job applicant or candidate about their salary history. Now, 29 cities, counties, or states have enacted salary history bans. And while you can't ask about former compensation or base future compensation on an individual's compensation history, you can always ask them about their salary or pay expectations. Asking, what do you expect to make in this role? That's always permitted 100% of the time. As we run through our mid-year review, we have three measures to cover: Columbus, Ohio, which joins Cincinnati and Toledo, Ohio, in prohibiting employers from asking applicants about their salary history or relying on salary history for compensation decisions. The law applies to employers with 15 or more employees in Columbus. New this quarter, Lehigh County, Pennsylvania. As I mentioned in our Ban the Box discussion, Lehigh County has passed a comprehensive anti-discrimination ordinance. Included within that ordinance is a ban from asking job applicants about their current or past compensation. And in Minnesota, any employer in Minnesota cannot inquire about an applicant's previous compensation or benefits, including remote positions. And here is a map I've created to show you the jurisdictions requiring that you either post or provide a salary range for any open positions. Most pay transparency laws note that the range you publish is what you reasonably expect to pay the worker. And here is a table that breaks down pay transparency laws passed or becoming effective in 2024. Colorado's pay transparency law is the most technical in the US, so bear with me, and I'm going to cover that right after this slide. So let's just move to Hawaii, whose measure only impacts employers with 50 or more employees and only applies to new hires. On the other hand, in Illinois, employers with 15 or more employees need to disclose the pay scale and a general description of benefits in job postings. There are also pay transparency requirements for internal positions in Illinois. And employers will have to announce any promotional opportunities to current employees no later than 14 calendar days after the employer advertises the job to prospective external employees. Maryland's extended pay transparency law will require employers to post the minimum and maximum hourly salary range that they will pay for a role in both internal and external job postings. This law, which applies to any job performed at least in part in Maryland, will also see the Commissioner of Labor and Industry provide a form for wage disclosure compliance, so be on the lookout for that. Minnesota's new pay transparency legislation will require employers with 30 or more employees to disclose starting salary ranges and a general description of benefits and other compensation for job openings. If a fixed pay rate is offered, it must be listed in the job posting, and salary ranges must not be open-ended. You have to have a close on that salary range. In Vermont, employers with 5 or more employees will be required to post the minimum and maximum hourly salary range for the job roles, including if tips or commissions will be paid as part of the compensation for that role. The legislation applies to positions performed in Vermont or remote roles predominantly conducted in a Vermont office. Vermont's Attorney General will provide guidance on the law's application before its effective date. And Washington, D.C.'s pay transparency measure requires that employers disclose not only compensation, but all monetary and non-monetary benefits to the candidate or the employee. So let's circle back to Colorado's pay transparency law. Colorado was the first state to enact such a law, a pay transparency law, back in 2021. And in 2023, it clarified and expanded its scope. Colorado's law requires publishing notifications for all job opportunities, including promotions. For the pre-hire process, again, before you hire someone, you have to notify existing employees about job opportunities, including a wage and salary range, a general description of benefits, other compensation, and the application's window closing date. Again, this includes for any promotional opportunities. As part of the post-hire process, within 30 days of selecting a candidate, you have to notify the colleagues of the new hire's name, their former job title if they were hired internally, their new job title, and how employees can express interest in similar opportunities, such as by visiting your job board or by contacting HR. So again, there are specific post-hire notice processes for your jobs that are filled, either for new hire positions or for promotions. There is an exception for employers not physically located in Colorado and with fewer than 15 employees working remotely in Colorado. All other employers must follow these notice requirements for all job opportunities available to internal candidates. That is Colorado's very detailed pay transparency law. All right. As we wrap our pay equity and transparency discussion, remember to assess your policies and procedures to comply with pay transparency laws and salary history bands. This means conducting a pay analysis and posting pay ranges, in many cases, both internally and externally. And if you're still asking candidates to disclose their former compensation, you might want to rethink that practice. Many employers are adopting universal practices to no longer ask about salary and are being transparent about their pay practices. There is definitely a shift in how employers are approaching pay. If you operate in Colorado, or if your jobs could be performed by remote workers in Colorado, it's worth taking a detailed look at their pay equity law. There's a link to a blog that I wrote that covers Colorado's law in detail in the resources section of this webinar. So that is everything from a pay equity and transparency discussion perspective. I realized we covered a lot of measures and I see several questions coming in. So please use that Q&A icon to submit your questions. We're going to get to those at the end of today's session. All right, so let's move into a discussion of miscellaneous legislation and litigation. This is our potpourri section, the stuff that's worth mentioning but doesn't really fit in elsewhere. Starting with California's Workplace Violence Prevention Act, which establishes the first general industry workplace violence prevention requirements in the US. Again, this is the first impression for a law like this. I've outlined some of those requirements on the screen, and I mentioned California's Workplace Violence Prevention Act for a couple of reasons. First, like I mentioned, it's the very first of its kind in the US. So you want to make sure that you're looking at this with a close lens and consider that pre-employment background checks could be identified within your plans as helping to mitigate risks to the workforce. And second, to remind you that recurring screening and criminal history monitoring are features that you may want to call out as part of your risk mitigation plans. So if you need any information on recurring screening or on monitoring, just let us know when you complete the survey in today's webinar. For what it's worth, I've included a link to Cal OSHA's Workplace Violence Prevention site, which includes helpful information and templates. I really think their site is really beneficial, especially if you haven't done this already. Take a look. Their templates are really beneficial. So check out their page for more information. Again, I've linked to it in the resources section of today's webinar. Moving on, Colorado's Job Application Fairness Act prohibits you from collecting any information related to age, date of birth, or dates of attendance or dates of attendance at or graduation from an educational institution on initial employment applications. Again, this is only relevant to initial employment applications. This information can be collected later in the hiring process, for example, when you request a background check. California, Connecticut, Minnesota, and Pennsylvania also have laws restricting age-related information in initial employment applications. So again, if you ask for any information about dates of attendance at schools as part of that initial employment application, you'll want to remove that in order to comply with Colorado's law. New York City employers must display the Your Rights at Work poster in a visible location for all employees and provide a copy of the Workers' Bill of Rights to current employees and new hires on their first day of work. The document contains information about worker classification, job applicant rights, pay transparency, salary history bands, rights when using an employment agency, and automated employment decision tools. So you're going to want to integrate this notice requirement, this poster, into your onboarding processes and ensure ongoing compliance. The poster includes a QR code, which will send workers to a multilingual site where they can look at their rights. Again, I bring this up because it talks about things like pay transparency as well as employment classification. So I thought it's something that you should be aware of. Okay. Let's shift gears and get some audience participation going as we're about halfway through today's webinar. If you've attended previous webinars, you know that this is my favorite part of the show. So what I'm going to do is I'm going to walk you through a fact pattern and then ask you to decide the case. So the facts are there on the screen. I'm going to give you a little bit more backstory than what you see so that you get just a few more details. So let's talk about the fact pattern. The plaintiff A deputy sheriff suffers from debilitating back pain. He injured his back for the first time at age 19 while pursuing a career as a professional motorcycle racer. The injury cost the plaintiff his racing career and much of his ability to work, walk, and lift items, leaving him with 2 steel rods in his back and an artificial lower lumbar disc in exchange. The plaintiff turned to law enforcement as a second career, but re-injured his back during an incident with an inmate. His medical providers prescribed pain medication, leading to an addiction, which he supplemented with alcohol and marijuana. It's worth noting that the plaintiff also developed an alcohol addiction. When seeking a controlled substance prescription in an emergency room, he goes into an ER seeking a controlled substance. A state monitoring system flagged him, and a nurse reported that action to his supervisors. His supervisors placed him on administrative leave and tested him for drugs, resulting in a positive marijuana test, negative for opiates, but positive for marijuana. A month later, the plaintiff was arrested, charged, and detained for deception to obtain dangerous drugs. The sheriff's department subsequently terminated the plaintiff's employment, citing his arrest, the positive marijuana test, and his guilty plea to that charge as violating department policies. So let's talk about the complaint. The plaintiff filed charges with the EEOC, the Equal Employment Opportunity Commission, for disparate treatment and failure to accommodate. After receiving a right to sue letter, he amended his complaint, alleging his termination was due to his addiction. He argued that officers without perceived disabilities kept their jobs after similar misconduct, and that firing him instead of helping him violated department policy. He cited 3 officers involved in alcohol-related misconduct who were allowed to enroll in rehabilitation programs and ultimately allowed to keep their jobs. He also referenced the collective bargaining agreement that he was subject to, which requires the sheriff's department to refer employees to an assistance program for personal problems affecting job performance. This is exactly what was offered to those 3 officers that also had alcohol-related misconduct. So those are the facts, and that is the complaint. So I am going to ask you to be the judge. It's your time to shine. Was the employer justified in terminating the deputy sheriff? Do you think that their actions were valid, or did they have a duty to reasonably accommodate his purported disability and get him help to treat his addiction? So I'm going to give you a few seconds to get your answers in. So go ahead and vote now. So we're only at about 5% of you. Now we're at about 10% of you. We have about 1,000 nons. So let's get a few more answers in so we get a good sample, and then we'll move on. Okay, we're at about 30%. When we get to 40%, I'm going to move it on, and we are at 40%. So was the employer justified in terminating the deputy sheriff's employment? Yes or no? Let's see what you have to say. Okay, so the majority of you say that the sheriff's department was not justified in terminating this deputy sheriff. So let's talk about the decision. Well, here's your answer. This is a win for the employer, and here's why. Under the ADA, the Americans with Disability Act, alcoholism is considered a disability, though employers can still hold alcoholic employees accountable for meeting performance and conduct standards. However, the ADA stipulates that an employee currently engaging in the illegal use of drugs is not entitled to its protections. According to EEOC guidance, drug use is current if it occurred recently enough to justify an employer's reasonable belief that involvement with drugs is an ongoing problem. In this case, the court found sufficient evidence of current drug use based on the employer's admitted marijuana use, that positive marijuana test, as well as withdrawal symptoms. Therefore, they excluded the employee from the ADA's coverage. So while alcohol is a qualifying disability, the fact that the employee was engaging in current marijuana use, which is federally illegal, and that positive drug test, that exempted him from the employer needing to reasonably accommodate him. So Employers should note that while the ADA does not protect medical marijuana users, the EOC may still require engaging in an interactive process with the employee to determine if other accommodations are available based on the employee's underlying disability. Additionally, state laws may offer employment protections for medical and even recreational marijuana users. We're going to talk about that in a minute. You might have been following recent news that has highlighted that the DEA, the US Drug Enforcement Administration, has issued a proposed rule to reclassify marijuana from a Schedule 1 to Schedule 3 drug. So the potential impact on employers will need to be evaluated if this reclassification becomes effective. But I think this is a really interesting case that shows us the juxtaposition between disabilities, drug use, and the need to accommodate. So that is a wrap on our litigation update. Thanks for playing along. I hope you enjoyed it. I certainly did. So let's keep things moving and talk about a few compliance takeaways for you to focus on. First, if you operate in California, make sure to check out Cal OSHA's website and implement a workplace violence prevention program. Even if you operate outside of California, you may consider looking at the state's framework as an opportunity to bolster risk mitigation within your company. Remember that recurring background screening and criminal monitoring could be good options for you. Let us know if you need more information on that. Second, make sure that you remove any age-revealing questions from the employment application for candidates in California, Colorado, Connecticut, Minnesota, and Pennsylvania. This includes dates of attendance at school. You may consider adopting a universal policy across the board. And finally, make sure that your workplace posters and notices are current, including the new Workers' Bill of Rights and Know Your Rights poster in New York City. A compliance tip, if you have New York City workers, you might consider publishing this on your talent website for good measure. And we are right on time to start talking about cannabis reform. I think that last case was a good segue into this section. You're going to hear me using the terms cannabis and marijuana and THC interchangeably. They are the same thing. I tend to do the same in my writing, so please don't let it confuse you. Again, cannabis, marijuana, THC, same thing for the purposes of today's discussion. Here is our medical cannabis map. Looking at your screen, you're going to see states in red where accommodation is likely not required, states in aqua where anti-discrimination measures are in place and where reasonable accommodation of medical marijuana is necessary, states in blue where the law is silent on the issue of accommodation, and Philadelphia shown in purple or wine, which has banned pre-employment marijuana testing. The remaining states in gray haven't passed a medical cannabis law. And when I talk about cannabis accommodation, much like we just discussed in that last case, I mean that in certain states, you cannot discriminate against an individual just because they are a lawful cannabis user. And of course, the need to accommodate not only differs by state, but also by role. So for example, there are typically, but not always, exceptions to accommodation for individuals in certain safety sensitive positions. And there are always exceptions for those in DOT regulated positions. That last case that we discovered, that we discussed, that was not a state that requires accommodation of medical marijuana. That's why the court was able to decide in the way it did. So let's move on and talk about one update, which is South Dakota. South Dakota has had quite the saga when it comes to medical and recreational marijuana legalization. In 2020, voters approved recreational legalization, but the state's Supreme Court overturned it on a technicality. In 2022, voters rejected legalization. It's going to be on the ballot again this November. So let's focus on SB 12. SB 12 allows employers to fire or refuse to hire patients for safety-sensitive jobs if they test positive for THC metabolites. So again, if they are a medical marijuana user in South Dakota and they are in a safety-sensitive job, they can be fired or employers can refuse to hire them. The law also prevents medical marijuana patients from suing for wrongful termination due to a failed drug test. Employers are not required to allow cannabis use or possession at work or permit employees to work under its influence. They can enforce drug-free workplace policies, including drug testing, in line with state and federal laws. No claims of employment discrimination or wrongful terminations can arise from enforcing these policies. So that is what SB 12 does. It clarifies the state of medical marijuana law in South Dakota. It'll be interesting to see what South Dakota's voters decide concerning recreational marijuana this fall. Speaking of which, here is our recreational map. As you can see on this screen, 23 states and DC have legalized recreational cannabis, also known as adult use legalization. While locations in red have no impact on employers, those in aqua, blue, or purple are different. Those jurisdictions shown in aqua allow for pre-employment testing for cannabis, but the statutes say that an employer cannot impact employment due to a positive test for THC. And in California and Washington, shown in blue, you will not be able to conduct pre-employment tests for non-psychoactive THC metabolites. That means that you cannot collect urine or hair samples in California and Washington that test for THC. If you want to continue drug testing in those states for marijuana, you'll either need to remove THC from your drug testing panels or move to oral fluid screening. Shifting gears, in New York State and Minnesota, pre-employment testing for cannabis is prohibited unless an exception applies. So again, please ensure that you've aligned your drug testing panels accordingly. Please let us know if you need help with this when you complete the survey at the end of the webinar. Just to bring you up to speed with what's going on in Minnesota, as of January 1st, 2025, employers will be able to consider oral fluid testing for drug and alcohol purposes. You can see the specifics there on your screen, but remember that Minnesota prohibits testing for THC in most cases, but otherwise, feel free to use oral fluid if you'd like, starting in 2025. So here is our compliance in focus summary. Instead of zero tolerance drug policies, focus on cannabis use and impairment at work and update your policies accordingly. Ensure that you can distinguish between medical and recreational marijuana use in drug tests and accommodate medical use where required. In some areas like Washington, D.C., all marijuana use must be accommodated, period. Know the laws in your jurisdiction. Modify drug testing panels to exclude marijuana where required, such as in Minnesota. In California and Washington State, use oral fluid testing instead of urine or hair for non-psychoactive marijuana metabolites. You are responsible for adjusting your drug test panels. Screening providers are not going to do this for you because we don't know if you are eligible for a legal exception. So contact us for help if you need help adjusting your screening panels. All marijuana legalization laws exempt DOT-regulated positions, federal contract positions, and some, but not all, exempt many safety-sensitive positions. If you're still confused about what is or is not allowed, then continue to get your questions in using that Q&A icon at the bottom of the screen, and check out the resources section of the webinar for more information. Okay, I'm going to zoom through some privacy, tech, and employment updates, including artificial intelligence. First, I've created this map to easily show you all current and soon-to-be effective data privacy laws. Newly passed laws are indicated by a star, and newly effective laws are shown in aqua. As a reminder, all states that have passed a comprehensive data privacy law have exempted information collected and reported in compliance with the Fair Credit Reporting Act. So this means that background checks, when conducted by a background check vendor or a consumer reporting agency like HireRight, are excluded from the scope of those data privacy laws. And here's a new map that I've created to start tracking the progression of AI laws that relate to automated employment decision tools. Automated employment decision tools are AI that makes or facilitates employment decisions. I think we're going to start to color this map in over the next year or so. So let's focus in on Colorado's AI law. This is the nation's first comprehensive cross-sectoral AI law. The Colorado AI Act targets high-risk AI systems. So those are those AI systems that significantly influence decisions in critical areas like education, employment, financial services, government services, healthcare, housing, insurance, and legal services. Employment is what we're really interested in. The AI law exempts AI systems that perform narrow procedural tasks or that don't influence final human decisions. So those are things like calculators, non-facial recognition, anti-fraud tools, and even chatbots. The AI Act aims to prevent bias and discrimination in AI decision making. It prohibits AI systems from causing unlawful differential treatment based on protected characteristics like age, race, gender, national origin. Both developers and users of those systems have to ensure that they don't perpetuate or exasperate those particular biases. For employers using AI in hiring, you're going to need to implement thorough risk management and impact assessment procedures to ensure your AI systems are fair and non-discriminatory. You'll regularly update public-facing disclosures and system documentation to maintain transparency and accountability about your use of these AI systems. You're going to proactively identify and address any biases or discriminatory practices that may result from AI-driven decisions. Governor Polis in Colorado, he signed the act into law, but his signing statement encourages lawmakers to support clarifying legislation in this next legislative session in 2025 before the act's effective date. So stay tuned for a lot of legislation to come out of Colorado, which we'll certainly cover for you. California is taking significant steps to regulate AI in employment. In May 2024, the California Civil Rights Council proposed regulations to clarify that using AI systems that harm applicants or employees based on protected characteristics is illegal, to require employers to keep employment records, including AI decision-making data, for at least 4 years, to ensure that AI does not replace the need for individualized assessments of an applicant's criminal history, to prohibit third parties from aiding employment discrimination through AI systems, and to provide examples of unlawful medical or psychological inquiries in AI assessments, and finally, to define key terms like automated decision systems, adverse impact, and proxy. If this is interesting to you, the California Civil Rights Council is holding a public hearing tomorrow, July 18th, via Zoom, where you can submit testimony or just listen in. Details are in the resources section of this webinar. It proves to be an interesting meeting, so I highly encourage you to listen in. Like you see on the screen, California is taking a two-pronged approach to regulation or legislation. So we also have AB 2930 that's been introduced to prohibit employers from using AI tools that would contribute to algorithmic discrimination. The bill would regulate AI tools making consequential decisions and require employers to evaluate the impact of AI tools, to conduct annual bias audits, notify impacted employees, form internal governance programs, and publicly disclose their AI systems and risk mitigation policies. So AI seems to be a very hot topic for California regulators and legislators. That is what's happening. Expect California to continue to push AI legislation in the next several years. And here's another new map I've created. This one tracks laws that impact an employer's collection and use of biometrics. So think like fingerprints, voice scans, facial scans, retinal imaging, and the like. States in red have passed standalone privacy laws concerning biometrics, while states in aqua have included biometrics data within the scope of the state's comprehensive privacy law. I'm never certain if biometrics laws are important to you, so let me know if they are when you complete the survey so I can figure out how much time I should dedicate to this topic. If it's not something that's important to you, I won't include it in future webinars. If it is important to you, I'll figure out how to fit this in. So let's go back to Colorado, where starting on July 1st, 2025, Colorado employers who collect and process biometric data from their employees must adhere to new disclosure, consent, and retention requirements as outlined in HB 1130. This amends the Colorado Privacy Act, the CPA. I've outlined a few key requirements for you on the screen. Again, if you have questions, just let me know in the Q&A icon. I don't want to spend a lot of time on this if it's not important to you. Quick note out of Illinois, the Illinois General Assembly passed SB 2979 to limit claims for per scan damages under the Biometric Information Privacy Act, the BIPA. This is huge, as it will greatly curtail the scope of damages for violations of the BIPA. Again, now a plaintiff can only recover a single set of damages against an employer, no matter how many times their biometrics were incorrectly collected. This is a huge win for employers, as we were seeing multi-million-dollar lawsuits being leveraged against employers. Again, only a single set of damages now as a result of this new legislation. As we focus on compliance, remember that FCRA regulated background check data is not in the scope of state data privacy laws, but remember, other employment related data in California is in scope. I've said it before and I'll say it again, there is a race to regulate AI in the employment lifecycle, and Colorado has mostly crossed the finish line with some technicalities. Expect clarifying legislation to be passed in the next year, and watch what's happening in California. Both the legislature and the Civil Rights Council are considering measures that would significantly change the way many employers interact with AI and related tools. Check out that Zoom meeting tomorrow if you're interested. And finally, remember that if you collect biometrics information, whether that be via a background check, a video interview, or even fingerprints or hand scans at a time clock, you need to make sure that you're complying with biometrics privacy laws. And that is our privacy, tech, and employment update. So as you get your questions in, here is a quick plug. We have several outlets of information for you to consume. So if something piqued your interest today, check out our resources library, our blog, and Forbes articles to learn more. And again, connect with me on LinkedIn, where I post a short video covering a new compliance topic every single week. So we've got a few minutes for questions. If I don't get to your question today and it's pressing, please let me know when you complete the survey and we'll get back to you more quickly. So let's get into our Q&A session. All right. So at a quick glance, there seem to be several questions concerning comments I made about pardon convictions. Again, a pardon conviction is not an expungement. They are different things. Pardon convictions will be reported unless a state law specifically restricts a consumer reporting agency from reporting it. So you'll see that in California or in New Mexico. From an employer's perspective, certain regulated job roles specifically require that employers bar individuals with specific criminal history, even if it's been pardoned. But for the rest of us, the majority of employers, there are no such restrictions. So you have to look at that state's law. I mentioned that Pennsylvania prohibits most employers from considering pardon and convictions. The same is true for Alaska, I believe. And from a federal perspective, the EEOC interprets Title VII of the Civil Rights Act as prohibiting employers from discriminating against individuals with criminal history absent justifying business necessity. So while you'll likely see a pardon conviction on a background check, it's up to you as to whether or not there is a business justification that warrants taking an adverse action based on that pardon conviction. So again, take a look at your policies and processes as to how you handle pardon convictions. In most cases, I would hazard a guess to say that you're probably not going to disqualify an individual based on a conviction that has been pardoned. But there may be some circumstances where you are justified in doing so. So again, that will require that individualized assessment. Looking on, there are several questions concerning unincorporated LA County's Ban the Box ordinance. In a nutshell, you can't ask a candidate about their criminal history until after a conditional offer and until after they've had an opportunity to review their criminal background check. So again, they need to have that criminal background check in their hand. They see exactly what you see before you engage in that dialogue about their criminal history. And it's voluntary as to whether or not they want to provide you with any evidence of rehabilitation. They don't have to provide you with that. And to the extent that they don't provide you with that, you can't hold it against them. Remember that you may have to conduct multiple individualized assessment if the candidate returns information that explains their criminal history to you. Also, remember that you have to both mail and email all pre-adverse and adverse action letters to the candidate if you have that email address available to you. So this is going to be a very different process for you, where you'll have to establish a process whereby you physically mail all letters. And then in most cases, if you have an email, also send out that email. You'll also recognize that that candidate is going to get those notices at two different times, right? If they get that email, they're going to get the email obviously first, and several days later, they'll get that physical mail. So you might want to let them know, hey, you're going to get physical mail as part of that email notice, so they're not confused by getting these duplicate notices. It's a little silly, but that's the way the ordinance reads, and that's what's required for compliance. Questions about the applicability of ban the box laws, whether or not they apply to individuals in the transportation industry. They do. There is no express exemption for any ban the box ordinance that I'm aware of that would specifically apply to the transportation industry. So if you are in the transportation industry, you will need to adhere to ban the box laws. And like I mentioned, there are many jurisdictions that require that that apply the ban the box ordinance to any job for pay, which applies to independent contractors. That means that if you are a transportation network company or other gig economy company, if you are utilizing those gig workers, transportation workers, they would also be subject to the ban the box ordinance in certain circumstances if required by that particular ordinance. Again, those were all the jurisdictions in that red color. A lot more questions concerning drug testing, pay equity, AI laws, much more than I can actually get to at this point. So we're going to follow up with you at the end. Thank you so much, though, for attending today's webinar. The engagement was incredible. You can expect this webinar to be posted to the HireRight resource library shortly, and you'll receive an email with your SHRM and HRCI credit next week. Again, you're going to get that information next week. Thank you for your time today. Again, take 60 seconds to complete the webinar survey. I take your feedback seriously. You know, some of you know that I've reached out to you personally based on your feedback. So let me know how I'm doing. It is my report card. And with that, we're going to chat again in the fall. Until then, thanks again for spending your portion of your day with me today. Look for updates on Forbes, the HireRight World blog, and connect with me on LinkedIn. Until we meet next quarter, thanks again for your time. See you all.